Hello class, today I'm going to be presenting When Going to Trial Would Be a Train Wreck by Franklin R. Garfield. My name is Yuritsa Zavala. So we're going to start off with categories of a case. This is what attorneys usually look for, some red flags and some green flags. For starters, what you want to look for as an attorney is when your fees are being paid concurrently. This is most likely going to help settle a case and prevent it from going to trial. If payment is in doubt, the goal is to get out of the case before going to trial. This is when attorneys usually tend to persuade for a settlement instead of going to trial, because then they will be struggling with fee resources and potentially go to trial for free. Another thing to look for is clients who are resistant to settlement but amenable to reason. This can usually prevent trial, but again, it cannot. It depends. It really just depends. And then something that attorneys all need to know when walking into a case is that not all cases can be settled. There is going to be cases where they will come across a hard client or a client that is wanting more resource. It just really depends, and we'll go through that throughout the slide. There's obviously many clients in a case. Every case is different. Some type of clients in family law cases, you'll find them being amenable to reason. This is the client you want to have. Sometimes it could take a friendly persuasion to talk them into settlement instead of going to trial. There's the deer in the headlights. This is a client who is unable to make hard decisions, and you usually find it difficult to have them settle a case. We also have clients whose position is determined by a sense of entitlement. This is usually more found in men. They think that because of like their position or like their power, that they are entitled to more. You also find the narcissistic client, as well as the client who does not take no for an answer. These two clients, again, usually tend to be male clients. So there's also clients who delay for their personal benefit. Sometimes it's beneficial for them to delay trial or delay settlement just because. And then you have the client who implicates psychological divorce. This usually means that they're negligent about the divorce, and it's kind of hard for them to adjust to what's going on and accept kind of like what is it called? I forgot the term of what it's called, but they're just basically in denial over what's going on with their case. Moving forward, here are some tactics to help avoid going to trial. One of the important resources to do is explain to clients downside risks of going to trial, both verbally and in writing. It's always good to have all your communication in writing as well. Providing a realistic worst case analysis is also well. Emphasis on payment, whether the client is going to be having to pay upfront or is it a pay as we go type of client. Another tactic is if clients show slight disappointment by the trial result, it is essential to give a rundown on how the case can go. Again, this ties to explaining the downside risks, but again, also having that in writing as well. If a client chooses to settle, explain the pros and cons, again in writing and verbally. Also providing updates in writing help persuade a client to settle and will protect the attorney if the client later seeks to hold the attorney responsible for his or her decision. This is, like I mentioned, it's almost to cover the attorney and their firm, because usually in worst case scenarios, clients do come back and blame the attorney for their outcome of their case. Another topic that the article covered was how to promote settlement. Promoting settlement is honestly the best way to avoid trial. You can do this by providing the client a dose of reality. Providing a second opinion can also be helpful. Usually, attorneys don't like to do this, but in some cases they do, depending on the case. The most effective way to promote settlement is refusing to finance litigation. This is again if you see that the case is going to be a free trial instead and the client won't cover the cost. Another last point is a client who has to pay for going to trial is less likely to want to pursue than one who is not paying. This ties with the promoting finance for litigation. Usually, clients who seek help want to it depends on the client, but most cases, clients do want to spend as little as possible. The article also did cover those clients who are resistant to reason. Some of these clients you'll be able to tell right away because they'll right away be the client that wants to go to trial just to prove a point. Some parties think of going to court as an opportunity for like their 15 minutes of fame or just again to prove a point. A lot of clients also go for it's called the chicken game to see who will do the most, basically. Another case that has happened before is the pleasure of tormenting. This can be spousal abuse. The clients only want to go to trial just to torment. Another reason why the client can go to trial has a lot to do with their attorney. Their attorney would want to win, and you'll see a lot of, well, you won't see, but there can be some times where legal representation gets compassionate. And this is when the lawyer or attorney gets involved, too involved, and even though the case isn't going anywhere, they still end up taking it to trial. The outcome can get a little bit messy, but there has been some cases like that before. Some things that attorneys have to consider is unhappy clients look to sue their divorce lawyers or blame them for the outcome of their trial or settlement. There was a quote in the article that said existing law provides that it is the duty of an attorney to, among other things, never reject for any consideration personal to himself or herself the cause of the defenseless or oppressed. There was also a section of Section 2335 of the California Family Code that reads, in a pleading or proceeding for dissolution of marriage or legal separation of the parties, evidence of specific acts or misconduct is improper and inadmissible. This also goes more for like domestic violence cases, because with domestic violence cases you will be able to find some of the evidence admissible, but that's just stuff to consider again as to when it can go to trial. Lastly, the article did cover a quote by Kenny Rogers from The Gambler, and it stated, "You've got to know when to hold them, when to fold them, and when to walk away and when to run. You never count your money when you're sitting at the table. There will be enough time for counting when the dealing's done. Staying in when you should get out virtually guarantees that you will end up with no money to count when the case is over." This is what the article said that every attorney should consider when going into a case and a trial, because it can go both ways, and it's better to just settle and not go into trial thinking that it's gonna be that you're gonna win. Basically, it could be either a loss or a win, and to not put your pennies in a basket. Overall, this was a really good, informative article. I definitely recommend reading it just because it had a bunch of more information that helped understand when a client goes to trial and why it's best to prevent that. So thank you all for watching, and thank you. Have a great day.